read that book before I knew about this.
Barb is not bad.
You got slide?
They usually have a monitor.
You got PowerPoint?
Yeah.
Okay, our next panel is focusing on perspectives in public policy. Since this panel has 5 speakers, I would ask that as questions arise, you fill them out on the, I put some extra cards on the tables in front of you. Fill out your questions, pass them to the end of the aisle, so as soon as the last speaker finishes, we can move directly into the Q&A section.
Okay.
Our first speaker is Joyce Tischler. Joyce is the co-founder of the Animal Legal Defense Fund. She's been one of the pioneers in the field of animal law for more than a quarter of a century. A California attorney, Joyce has handled some of ALDF's earliest cases, including a 1987 challenge to the U.S. Patent Trademark Office ruling that genetically allowing the patenting of genetically altered animals. Serving as ALDF's executive director for 25 years now, Joyce now serves as the agency's director of litigation.
Well, I want to thank the ABA and Duke Law School for inviting me to speak here today. This is a first on several levels. I don't have a PowerPoint presentation, number one, and I'm that animal rights radical you've been hearing about. I don't often have the opportunity to meet with scientists and patent lawyers and government regulators, so I'm very excited about this, and I'm looking forward to chatting with as many of you as I can. Higher animals are useful in research and testing. Higher animals are sentient. They feel pain and pleasure, and they think and they feel. And these are diametrically opposing viewpoints, and there is a real dearth of dialogue in this country to try to bring us closer on those two diametrically opposing viewpoints. Animal protectionists, animal rights people, and scientists have been demonizing each other for so long that has become our default position. We seem unable to move out of that, and I don't think it would be an easy thing to do. But one way to start is to remind ourselves that we are all compassionate people. We're all motivated by trying to reduce the amount of suffering in the world. We all feel empathy. Where we differ is where we draw that line. Who's within the circle of compassion and who is not included within the circle of compassion? Do I care about animals and not human beings? Of course not. Do you care about humans and not animals? Of course not. Equally emphatic no's on both points. If we can start with that assumption, then is there some middle ground on which we can meet? And for selfish reasons, for the sake of the animals whose lives and whose interests I work to protect, and for my own personal growth as an individual, I sincerely hope we can. I'm an attorney, and in my mind, my clients are the animals. And I've said that slowly because I realize for some of you that was a very strange thing to hear an attorney say. I'm trying to make a point. I've spent most of my career working to bring the interests of animals into the courtroom and into the balance in our society. If I were an attorney who represented people in a comatose state, how would I determine what the interests of that person were? If I was an attorney who represented month-old children, how would I figure out what the interests of that client were? I try to figure out what the interests of my clients are. I'm not Dr. Doolittle. I don't talk to animals. They don't talk back to me. But we do know a lot about animals. A lot of it's common sense. Go home tonight, and when your dog greets you at the door and that tail is wagging, something's being communicated. And if you say, hey, let's go out for a walk, you know that that animal has an interest in going out for that walk. That's pleasurable. And that animal's communicating that to you. So there's a lot that scientists have taught us about the needs and the interests of animals. And I try to stick as close as I can to the facts. I've been asked to speak about the patenting of animals, and I will speak about that issue in an unbiased manner to an extent, but frankly, I always go back to the fact that I represent the interests of my clients. In 1980, as was mentioned earlier, the U.S. Supreme Court decided Diamond versus Chakrabarty, and in the materials that were given out, I included a copy of that decision. It was a 5-4 decision, which is a close decision. It means that it could have gone either way. But the holding was that non-naturally occurring microorganisms, genetically altered Pseudomonas bacteria, were patentable subject matter, and that they were manufactures or compositions of matter. The court was taking an aggressive approach. It interpreted the Patent Act broadly, and there was little support for that interpretation from the legislative history or from the Act itself. It moved into a very complex area with complex policy implications, and it really did not do what a lot of courts now do today, which is say this is really a matter for the legislature. Following that decision, on April 3rd, 1987, the Board of Patent Appeals and Interferences, relying on the Chakrabarty decision, held that genetically altered oysters were patentable subject matter. They denied the patent on the ground of obviousness. That was the Ex parte Allen case. 4 days later, on April 7th, 1987, the Commissioner of the U.S. Patent and Trademark Office, I refer to it as the PTO, announced a new rule in which the PTO determined that non-naturally occurring, non-human, multicellular living organisms, including animals, are patentable subject matter. Until the promulgation of that rule, the PTO had never granted a patent on an animal. Historically, it had considered animals to be, quote, things occurring in nature, not a patentable manufacture. For many people, including me, the PTO's rule was not a logical extension of Chakrabarty, because in deciding Chakrabarty, the U.S. Supreme Court was influenced by the characteristics of microorganisms. And I'm quoting, modified microorganisms claimed by Chakrabarty are analogous in practical use to inanimate chemical compositions such as reactants, reagents, and catalysts used in the chemical industry. In short, we think the fact that microorganisms are alive is a distinction without legal significance, and that they should be treated no differently than chemical compounds. The distinction between life and non-life was not relevant to the court. A microorganism, a minute piece of living matter, and a chemical compound are not legally distinguishable. The Chakrabarty court was focused solely on microorganisms. In Allen, the board was focused on oysters. The PTO expanded that to all animals. A bacterium is an oyster, is a chimpanzee. The most fundamental division in modern taxonomy is between eukaryotes and prokaryotes. All animals and plants fall into the class called eukaryotes, primarily sexual organisms having a nuclear membrane, mitochondria. Prokaryotes, such as bacteria, are single-celled, asexual organisms lacking a nuclear membrane, mitochondria. In promulgating its rule, the PTO abandoned the distinction between simple, unicellular life forms that have been the subject of patents since 1873 and highly complex beings with highly developed nervous systems, intelligence, the ability to engage in goal-directed behavior, and the capacity to suffer. Now, we could spend a lot of time talking about the arguments in favor of patenting animals. It benefits human society. In agriculture, transgenics will produce farmed animals who are more resistant to disease, produce higher yields of meat, require less nutrients, offer lower fat, lower cholesterol levels. In biomedical research, patenting allows researchers to alter animals so that they develop diseases, rather, patenting doesn't, but the genetic alteration allows researchers to alter animals so that they can develop diseases that the researchers are working to understand and develop treatments for. Patenting provides significant economic incentive to inventors and to corporations that wish to invest in research. It allows them to protect the investment of significant amount of time and money. And it helps the U.S. to maintain its leadership in transgenic research. Arguments against? Well, for family farmers, it has seemed like one more nail in their coffin in their efforts to compete with larger producers. Family farmers have been forced out of business and will continue to be. For consumers, there's the fear of what some people call monster meat, the GMO meat. Some people are looking for the packages that say this is non-GMO. It raises fears for people who are uncomfortable about being part of what they see as an experiment that they don't understand. Finally, from the perspective of people like me, There are ethical and moral issues that were raised and that were not answered. What I do, and the reason that I do it, is that animals are degraded and exploited in many segments of our culture, and because of that, they suffer. Sometimes their suffering is very long-term, and it's very intense. For me, genetic engineering produces animals with painful abnormalities. It encourages the increased use of animals in research that is harmful to the subjects of the research, and the current regulatory framework provides inadequate legal protection to the animals used in research or raised for food. Within a few months after the PTO announced its new rule, we filed a lawsuit, as was mentioned. We challenged the rule as violating the Administrative Procedure Act, claiming that the PTO had failed to provide notice and an opportunity to comment, and the animals were not patentable subject matter. We lost the lawsuit, as is obvious. We lost it on procedural grounds. We never got to the merits. Why did we sue the PTO? Well, it was not to be a fly in anybody's ointment. It was not to be a pain in your posterior. It wasn't because we don't like large corporations or we don't like people making money from patents. It was very simple, really. No one was discussing the ethical, moral implications of this decision. And for us, we feared and see a significant increase in animal suffering. The PTO and the courts in the Quigg case, our case, Alder versus Quigg, did not engage in a serious, thoughtful analysis of what their new rule would mean, as opposed to the Canadian Supreme Court, which did engage in that sort of debate. When ethical issues get swept under the carpet, they don't go away. Rather, they fester, and they keep coming up over and over. In 2004, the American Anti-Vivisection Society and Patent Watch Project filed a request for inter partes re-examination of a patent issued to the University of Texas. This patent covered live beagles, dogs, who were rendered immunosuppressed by steroids and total body irradiation. AAVS challenged the patent on several grounds relating to the obviousness of the invention in light of prior art. They also argued that beagles are not machines or compositions of matter. The PTO decided to re-examine the patent, and the University of Texas abandoned its claim. Earlier this year, 2007, the AAVS has filed another inter partes request for re-examination of a patent. This one involves rabbits. If you're interested in this, as I'm sure many people are, you can check their website at www.stopanimalpatents.org. As I said, the ethical, moral issues don't go away. The Federal Patent Act defines patentable subject matter as any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. Our language guides our conduct. If we call animals manufacturers or compositions of matter or models, we treat them as things. They're disposable. They're not worthy of moral consideration of their needs. If we deny that they feel pain, we tend to get lax about giving them pain relief. Animals are not referred to as machines or manufacturers in current literature, dictionaries, or commonly used language. If you look at Webster's or Random House, a thing is defined as an inanimate object without life or consciousness. There are anti-cruelty laws in every state, and I don't want to step on Bill's talk, but the very existence of those anti-cruelty laws acknowledges that animals are the subjects of special concern. Yes, they are property, but they are property that requires humane treatment. There are no anti-cruelty laws for shovels, or toasters, or automobiles, or bacteria. If you look at the wide variety of federal laws aimed at the provision of humane treatment for animals, Animal Welfare Act, Marine Mammal Protection Act, the 28-hour transport law, the Humane Methods of Slaughter Act, those laws only protect multicellular complex organisms. And the existence of those laws implies a consensus in our society that animals are intrinsically and qualitatively different from other forms of property. They have the capacity to suffer, and they are deserving of protection from suffering. And again, there's no statute that covers the humane transport or slaughter of a toaster. So why does our society care about a dog or a mouse but not a toaster? It's pretty obvious. the ability to feel pain, the ability to feel pleasure, the development of a consciousness of one's own existence, the capacity to engage in activity related to survival, propagation. These are all attributes that higher animals share with human beings, and a toaster does not. Animals use and manufacture tools. They communicate with members of their own species. They communicate with us. They have highly developed societal orders, and I'm talking about higher life forms at this point. There are numerous philosophical treatises and articles that have argued that animals have verifiable interests and awareness, and consequently should be and must be the object of human moral concern. So, when the PTO determined that an animal is no more than a mere composition of matter or a manufacture for the purposes of patent law, those were fighting words for me, and it raised a profound issue. Is there no dignity in higher animals? Are higher forms of life, other than human beings, nothing more than an accident? Are they merely matter? There are many folks, some of them here I'm sure, who would rather not have this discussion. But I have to ask, in bowing to innovation, did the PTO inadvertently set us back ethically and morally? The patent law does not operate in a social vacuum. Congress has not acted, the discussion has not occurred, it's unresolved, and it's just hanging out there. Enhancing technological progress without resolving the underlying moral and social consequences is a mistake. For those of you who have children, you've probably seen the movie Matilda. I saw it when my daughter was younger. And there are many wonderful scenes, but there's this wonderful scene in which the wonderful Danny DeVito stands in front of Matilda, and he's an absolutely awful parent, and he says, "I'm big, you're little. I'm smart, you're stupid. I'm right, you're wrong." And within the debates that we've had between animal rights, animal protectionists, and scientists, we've often taken that stance with each other. And so I just wanted to let you know I've come to this conference not to take that stance, not to browbeat, not to point fingers, but to deliver a message as one compassionate person to other compassionate people, that suffering matters to the individual who is experiencing the suffering. And you're in control, many of you, of my clients' lives and well-being. I hope we can continue to dialogue and to find some middle ground. And I hope that as you go back to what you do, your important work, you remind yourself on a daily basis of what a heavy responsibility you have. Thank you.
Our next speaker is Cathy Liss. Cathy serves as president of the Animal Welfare Institute and legislative director of the Society for Animal Protective Legislation. Cathy works on a variety of legislative initiatives before the U.S. Congress and various state bodies. She has particular expertise regarding the Federal Animal Welfare Act and has lobbied for adoption of the 1985 Improvement Standards for Laboratory Animals, amendment to the Animal Welfare Act. She's conducted site visits of animal research laboratories, animal dealer premises, animal auctions, animal factories, and family farms.
I don't know if it's a good idea to dim the lights too much, this being the post-lunch hour. And I should begin by telling you that I really probably should not have attempted to do a PowerPoint. My staff typically have really guided me through the process in the past, and I decided this time I was going to go it alone. So bear with me, and at least I feel the good news is that I don't think any of the slides are going to be upside down. Now let me start by seeing if I can figure out which way. Hey, okay, I just thought I'd give a little bit of background about the Animal Welfare Institute. Sorry. In case you're not familiar with the organization, we were founded in 1951, and the initial work done by the Institute was on laboratory animal welfare. The founder of the organization, Christine Stevens, her father was the head of the Department of Physiology at the University of Michigan. And he was concerned about conditions for the animals in the laboratory. At that time, there were no federal protections for them, and felt that something needed to be done. We were modeled on the Universities Federation for Animal Welfare, that is a science-based welfare perspective on improving the conditions for animals in the laboratory. Since that time, we've expanded to a wide array of other issues, origin of the Save the Whales campaign, wildlife issues, endangered species, and farm animal issues, as was mentioned. Certainly, as you're well familiar, I imagine, we do work on the 3 R's of Russell and Birch, the alternatives, and we have a very strong lobby component working on, again, a full array of federal legislation, including the original Animal Welfare Act, though that was before my time at the Institute, and various amendments thereafter. We publish a number of books, and we make most of them available free of charge. Occasionally, we charge somebody cost price for them. We are in the process of updating our book, Animals and Their Legal Rights, which gives a history of how various federal laws got passed and information on state laws and international laws as well. And then I just wanted to show you a sampling of some of the publications that we've done on the welfare of animals in the laboratory. And most of these are geared towards enriching the environment for animals in the laboratory. And this is our most recent publication. And this is a number of dialogues that have taken place on the internet regarding some key issues brought up, particularly by animal technicians. Just a quick overview of what I was planning to talk about. The Animal Welfare Act excludes the two main groups of animals that are used in biotechnology, rats and mice, and farm animals used in food and fiber production. A second topic would be that other laws governing the process of experimentation in biotechnology overshadow or displace the focus from the humane treatment of animals. And two critical issues, that is pain relief for animals and alternative to animals, take a backseat to scientific inquiry and profit. And finally, that biomedical experimentation industry interprets the Animal Welfare Act to mean that any regulation which increases costs, that is, perhaps by improving the housing for animals in the laboratory, actually interferes with research and should be prohibited. And this is not what the statute provides. This interpretation actually railroaded USDA's efforts to implement a federal mandate for psychological well-being for primates, as required in the 1985 amendment to the Animal Welfare Act. Again, as I said, the Animal Welfare Act actually excludes the two main groups of animals used in biotech, the rats and the mice, and farm animals that are used in food and fiber production. Rats and mice and birds, and I should add right here that I have birds in parentheses. Sometimes I might have put them in and sometimes they might be out. No offense to birds, just as we're talking biotech, the emphasis here is really more so the rats and mice, though this decision ultimately affected birds as well. And they had been covered under the Animal Welfare Act from the 1970 amendment. The Animal Welfare Act defined an animal as, quote, such other warm-blooded animal as the secretary may be determined as being used in research. And this is a letter written by Senator Bob Dole as someone deeply involved in the process of revising and expanding the provisions of the Animal Welfare Act. I assure you that the Animal Welfare Act was meant to include birds, mice, and rats. And he was the sponsor of the 1985 amendment and the 1970 amendments to the Animal Welfare Act. No one disputed that rats and mice were used in research. In fact, we agree they constitute somewhere around 90% of the animals that are used. And yet USDA defined animal by regulation as excluding these animals. Just to get an image of what is going on in some research laboratories, these are US laboratories. USDA claimed it did not have the resources to inspect facilities using these animals, therefore it excluded them. Consequently, the number of facilities using just these animals grew exponentially, thereby avoiding USDA inspection altogether. Two lawsuits challenged that definition as thwarting the congressional intent. The first was Animal Legal Defense Fund versus Madigan. As you can see, it was later reversed on standing grounds, and then Alternative Research and Development Foundation versus Glickman. And as you heard about earlier this morning from Dr. Goldentier, Senator Jesse Helms, as his parting shot before retiring, introduced language that excluded these animals from the Animal Welfare Act specifically. These animals lost the protection that they needed under the Animal Welfare Act without ever having even had the opportunity to actually benefit from it. A tragic event, undoubtedly permitting much unnecessary animal suffering. The United States is completely out of step with the rest of the developed countries who conduct research. And let's not forget the farm animals. Animals used in food and fiber production are also specifically excluded from the definition of animal and the protections of the Animal Welfare Act. The language is, quote, other farm animals such as, but not limited to, livestock or poultry used or intended for use as food or fiber or livestock, or poultry used or intended for use for improving animal nutrition, breeding, management, or production efficiency, or for improving the quality of food or fiber. That's directly from the Animal Welfare Act, the exclusion. Animal protection is being trumped, that there are other laws governing the process of experimentation and biotechnology, and they overshadow or displace the focus from that of protecting animals. Timeline of some events that happened from about the mid-1980s on forward. 1985, the Health Research Extension Act, quote, Animals in Research, which provides a statutory mandate for the Public Health Service policy. It's not an animal welfare statute. And I would say, based on my involvement in seeking the 85 Amendment to the Animal Welfare Act, I believe it was encouraged as and hoped to be an alternative to actually passing the additional amendment to the Animal Welfare Act so that you would have guidance instead of a legal mandate. But fortunately, just about a month after the Health Research Extension Act was passed, the Improved Standards for Laboratory Animals Act was adopted. The Health Research Extension Act, as I say, preceded it by just about a month, but it set the stage for how the Improved Standards for Laboratory Animals Amendment would be interpreted and how its regulations would be developed. In 1985, the Interagency Research Animal Committee, they used to call it IRAC. I imagine they won't be using that acronym. They promulgates the U.S. government principles for the utilization and care of vertebrate animals used in testing, research, and training. The principles are adopted by U.S. government agencies that either develop requirements for or sponsor procedures involving the use of vertebrate animals. The principles were incorporated into the PHS policy in 1986. And the 1985 amendment to the Animal Welfare Act included that the Secretary shall consult and cooperate with other federal departments, agencies, instrumentalities concerned with the welfare of animals used for research, experimentation, or exhibition, or administration of statutes regulating the transportation and commerce or handling in connection therewith. At the very end, you'll see Secretary shall consult with the Secretary of Health and Human Service prior to the issuance of regulations. And with not getting the Health Research Extension Act as the sole measure that was adopted by Congress, this was a way to have other agencies be able to have some dictates over USDA. The Animal Welfare Act emphasizes animal welfare very clearly. The standards were promulgated by the agency and they're enforced through unannounced inspections. At research laboratories, those inspections are conducted by veterinarians. The Health Research Extension Act is research focused. Animal care is secondary. Guidelines are established by the National Academy of Sciences through the Guide for the Care and Use of Lab Animals. Self-regulation and self-oversight with assurances to NIH that animal welfare will be provided. And I should say one other difference between the two, as an example, if a complaint is called into USDA regarding, and Dr. Goldentier will correct me if I'm wrong, if a complaint is called into USDA and it's substantial enough, they will go and conduct an unannounced inspection of the facility and assess the situation and fill out an inspection report at the time. The National Institutes of Health, if they get a similar kind of complaint, the first response is to call the institution and ask them what's going on. Very different perspective. In 1986, the Council on Natural Resources and Environment published the Coordinated Framework. It guides and directs agencies about jurisdiction over various products of biotech. And in 1990, the Office of Science Technology Policy, working in conjunction with the President's Council on Competitiveness, published the Scope Policy document. And you heard a little bit about it earlier. It provides oversight to be exercised by an agency only when there's evidence indicating there's an unreasonable risk associated with the bioengineered product or organism. Oversight is not to be exercised simply because the product is bioengineered. And the risk assessment is to focus upon the characteristics of the product itself and not by the process by which it was created. Two key issues, particularly coming from the welfare perspective, are pain relief and provision of or search for alternatives. And these tend to take a backseat to scientific inquiry and to profit. Some of the developments and applications of biotech involve procedures that cause animals pain, suffering, and distress. A substantial number of animals are used. They encourage a wider variety of applications, leading again to increased animal use, and increase the perception of animals as commodities for human use and or gain, such as research tools or units of production, rather than as the sentient beings that they are. Large numbers of animals are used in the creation of genetically modified animals with low success rates. Procedures used to create genetically modified and or cloned animals, again, cause pain, suffering, distress. Adverse effects as a consequence of genetic modification or cloning can have profound effect on animal health and welfare. And most importantly, actually I think will be the next one, the welfare and scientific usefulness of mutagenized animals cannot be guaranteed. It's critical, there are unique challenges that we face, and this is, I think, where we need as a group to move forward, that modern technologies have had and are clearly going to continue to have a serious adverse impact on animal use and the nature of harms caused to them in scientific research and in agriculture. Technology is progressing at a rate that's outstripping public understanding and ethical and public debate. The lives and welfare of animals involved in biotechnologies need to be acknowledged and awarded the due priority. It's critically important that all relevant regulatory systems are updated to take into account the animal welfare, ethical, and social implications of the development and intended use of all modern biotechnologies. There needs to be effective liaison, coordination, and definition of responsibilities within and between the relevant legislative bodies concerned with a particular biotechnology issue. The regulatory framework for each technology must encompass a process that enables a critical scrutiny of potential harms to the animals and intended benefits, and a careful weighing of these. Regarding the Guide for the Care and Use for Animals, it was last published over 11 years ago. The Animal Legal Defense Fund won a victory against the National Institutes of Health and National Academy of Sciences on the issue. That is, the NAS committees were subject to the Federal Advisory Committee Act, and therefore all the documents and drafts and meeting minutes that had before that time not been public were then made public. And these documents revealed that two controversial issues during writing of drafts and meetings were pain and alternatives. Both issues were relegated to bibliographic reference section of the guide. In 1987, a pain scale was drafted and published as part of the proposed regulations for enforcement of the proof standards for animals amendments in the Federal Register. But no scale was ever approved in the end. USDA should implement a scale for use in assessing pain and distress experienced by animals used for experimentation, and NIH should apply a similar system and scale, particularly given that rodents and farm animals for agricultural purposes are not covered under the Animal Welfare Act at present. USDA regulations and policies assess pain and alternatives to animals, but currently, in response to a mandate from the Office of Management and Budget, all of the policies by USDA's Animal Care Division are subject to public comment period now, and there may be revisions. The biomedical experimentation industry interprets the Animal Welfare Act to mean that any regulation which increases costs, for example, the better housing for animals, actually interferes with research and should be prohibited. This interpretation railroaded USDA's efforts to implement the mandate for a physical environment adequate to promote psychological well-being in primates in the 1985 amendment to the Animal Welfare Act. In 1991, USDA finalized its psychological well-being regulations for primates, providing that each regulated entity will develop its own plan for providing enrichment to primates. Key to this is that these plans are kept on site of each individual research institution, and so they're not available to the public through the Freedom of Information Act. In 1970, Congress stated that under the Animal Welfare Act, regulated research facilities still, quote, held the key to the laboratory door. And through the 1985 amendments, Congress opened that door and decreed that methods of testing that do not use animals are being and continue to be developed, which are faster, less expensive, and more accurate than traditional animal experiments for some purposes. And further opportunities exist for the development of these methods of testing. That measures which eliminate or minimize the unnecessary duplication of experiments on animals can result in more productive use of federal funds, and that measures which help meet the public concern for laboratory animal care and treatment are important in assuring that research will continue to progress. The Animal Welfare Act provision drawing the line between what USDA can regulate and what it cannot reads as follows: that nothing in this chapter, except as provided in paragraph 7, shall be construed as authorizing the Secretary to promulgate rules, regulations, or orders with regard to the design, outlines, or guidelines of actual research or experimentation by a research facility, or as determined by such research facility. And thus, in actual experimentation, USDA is not to regulate, with the exception of issues regarding pain and alternatives. However, what's critical is that this provision does not detract from USDA's primary role as setting and enforcing standards for animal care outside of experimentation, as well as in the areas of pain and after experimentation and the use of alternatives to animals. Wanted to express appreciation to assistance provided by Valerie Stanley and information provided by Dr. Osborne at the RSPCA. Thanks very much for your time.
Thank you, Cathy. Our next speaker is Dr. B. Taylor Bennett. Dr. Bennett is the Senior Scientific Advisor for the National Association for Biomedical Research. Prior to moving into this position, Dr. Bennett served as the Associate Vice Chancellor for Research Resources and the Director of the Biologic Resources Laboratory of the University of Illinois at Chicago. Dr. Bennett's professional interests are centered upon improving the quality of care provided to laboratory animals. And he served as the senior author of The Essentials for Animal Research, a primer for research personnel published by the National Agricultural Library.
Thank you. Figuring this out before I get started. I'd like to thank the organizers for inviting me to be part of this symposium. It's kind of one of those life-altering star alignment events in my life, because I was actually born in Durham, North Carolina, a lot longer ago than many of you remember. In fact, my father was a physician in the Army. He was from West Tennessee, and my mother was a nurse from Vermont, also serving in the Army stationed here. So when it comes to, I often introduce myself as a hybrid. Some of the people in the room will recognize what that means. Also, my son's an attorney, and he moved back home to go to law school, and I changed my impression about the educational experience attorneys have, because this one test a course is not the way veterinarians think, I can tell you that. I like many opportunities to succeed or fail, because I usually mess the first one up. And thirdly, he's actually on the faculty at DePaul Law School, too. But thirdly, my daughter's name is Raleigh, so there's kind of this triangle coming together here. So now that you know about my personal life, I think you should probably know about the perspective, the person who's going to give you the perspective. As you know, the title of my talk is Regulation of Animal Care, a Veterinarian's Perspective, and this veterinarian has been around a while. I spent 37 years managing animal care programs at one of the largest health science centers in the country. But more, I think, important is that I was the only one of 100 veterinary students who entered Auburn University in 1965 who actually wanted to go into research and be a laboratory animal veterinarian. In fact, I took part in the first course in laboratory animal medicine, I think, given at a vet school. And as part of that, as I was telling Betty this morning, I had to study the original Animal Welfare Act, and that was before highlighters. I went to school pre-highlighter, so I may be one of the few people in the room that's ever seen that thing and certainly still has it in their files, right, Betty? So I've been doing this for a long time. In fact, I got involved in the regulatory process in the 80s as a member of NABOR's Ad Hoc Regulatory Advisory Committee, which is made up of veterinarians from academia and the pharmaceutical industry, and was involved in that whole process of the 85 Amendment and the 6 and 7 year process of going from proposed rules to final rules. I think I can honestly say that I tried to manage progressive animal care programs throughout my career. These programs were heavily based on an educational component. We had mentioned that we wrote the book that the USDA used to train investigators for years. We also had the first course, I think, mandatory course for graduate students. Was also involved with a postdoctoral training program for laboratory animal veterinarians for years. And I think I've had an ongoing dialogue, which I always thought was positive, with the regulatory and funding agencies on these issues. I've spent a lot of time on the podium with representatives of the USDA talking about the directions we come from. As a laboratory animal veterinarian, whether you're in the academic institution or the pharmaceutical institutions, organizations, we deal with regulations, and some are requirements, as Cathy pointed out, as opposed to regulations. At least 3 sets of regulations and requirements, and sometimes 4. Primarily, of course, is the Animal Welfare Act, which Betty gave the history of, which licensed the dealers, registers the research institution, and then is made up of a series of definitions, regulations, and standards. The Public Health Service policy, which requires a letter of assurance, and I'll give a little more detail on that later, which uses the Guide for the Care and Use of Laboratory Animals as the basis for your program evaluation. Over 650, I think over 750 organizations now are accredited by the Association for the Assessment and Accreditation of Laboratory Animal Care International, or ALAC, which uses as the basis of the foundation of its program, the Guide for the Care and Use of Laboratory Animals. And depending on where you are, you may also have to deal with the FDA and its good laboratory practice. So laboratory animal veterinarians should go to law school. We spend so much time dealing with regulations. So let's take a look at the Animal Welfare Act. The Act and all the regulations can be found on their website at the Blue Book, and it's found in the Code of Federal Regulations under Title IX. Subchapter A is animal welfare, and as I said, it's made up of really 4 parts, but the 4th part has more to do with how the agency itself implements the Act. But the regulations set out the rules and processes for the institutions. The standards set out the standards for the daily care and transportation of those animals used in research. And that's an important distinction there. So, when it comes to being a veterinarian, our job is to provide adequate veterinary care. And within subpart C of those regulations, there's the section on research facilities, and section 2.33 deals with attending veterinary care and adequate veterinary care. And what it tells the institution is they must have an attending veterinarian. And if it's a part-time or consulting, there has to be a written program. In fact, They have a form that you can use to follow. The larger actually your program is, the more extensive your written program is actually going to be. Program that I managed had 9 veterinarians involved with it at any one time, and so it was fairly extensive. It also requires the institution to give that attending veterinarian the appropriate authority for the provision of adequate veterinary care, as well as the adequacy of the other aspects of the program, which in my mind means the standards, the quality of the facilities, and everything else you have to do in order to maintain an environment for animals so that research can be conducted. The veterinarian must be a voting member of the IACUC, the Institutional Animal Care and Use Committee. Now, Subpart B talks about, again, gives some more marching orders to the institution, and probably the most important part of the regulations when it comes to adequate veterinary care is that the institution is required to provide the appropriate facilities, personnel, and equipment and services so that the veterinarians and the veterinary staff can do their job. Section 2 then lays out the, subsection 2, the use of the methods that we need to have. What does a program of adequate veterinary care involve? And it involves preventing, controlling, diagnosing, and treating diseases and injury, and the availability of emergency, weekend, and holiday care. It also requires that there be daily observation of all animals to assess their health and well-being. Now, that doesn't mean that the attending veterinarian is the one that has to go around and look at all 40 or 50,000 animals that you may have in your facility, but it does mean you have to have a program for daily observation and reporting on a 365 a year. The veterinary care program also includes guidance to principal investigators and other personnel involved in the care and use of animals regarding handling, immobilization, anesthesia, analgesia, tranquilization, and euthanasia. So the veterinary staff is responsible for training those who care for and use laboratory animals. And the program also must include adequate pre-procedural and post-procedural care in accordance with current established veterinary medical and nursing procedures. Now that's what's in the regs under adequate veterinary care, but there are other parts of the regs which dictate the program of veterinary care. One of those that people don't generally think of is the annual report, which is in 2.36. When the institutional official signs the annual report, one of the certifications they are signing for is assuring that professionally acceptable standards governing the care, treatment, and use of animals, including appropriate use of anesthetics, analgesic, and tranquilizing drugs prior to and during and following actual research, teaching, testing, surgery, or experiments were followed by the research facility. This extends the program of veterinary care to the actual conduct of the research. It doesn't say that within their section on adequate veterinary care, but it's a certification that the institution must make. And I can assure you, if you look at the list of violations that the USDA reports every year, there seems to be a lot that are adequate veterinary care, but a lot of those actually are taking place in investigators' laboratories. Many of them have to do with something that's the bane of every institution, and that's outdated drugs. There can be a drug in the cabinet that's got so much dust on it, you know it's never been used. I actually once found something in a lab that was older than I was, which meant that it was really old. And so we have whole teams of people that go around and make sure there aren't any outdated drugs so that the veterinary care program doesn't look like it's getting slammed for something they didn't do. And lastly, I think what's most important is that one of the big responsibilities of this Institutional Animal Care and Use Committee is to review the facilities and the programs twice a year and report to the institutional official any deficiencies or any areas that need improving, and this applies to the program and the facilities available for the veterinarian to provide adequate veterinary care. The Public Health Service policy, I like pictures, can be found there, and as Cathy indicated, the Public Health Service policy is intended to implement and supplement the IRAC principles. Does seem like an oxymoron, doesn't it? But anyway, implementation by awardee institutions requires this letter of assurance, which at one time prior to 1985 was a one-pager. Now these things can be, 100 pages long because they lay out specifically what has to be in there. And in that, the institutional program is required to follow the guide for the care and use of laboratory animals. You have to lay out the functions of the IACUC, the lines of authority and responsibility of those involved in the animal care program. And what is interesting is if you are an ALAC accredited facility, that provides them assurance that you're following the guide for the care and use of laboratory animals. So initially, when you had to file these letters of assurance, it made it a little bit easier to be ALAC accredited. These IRAC principles, which actually stands for the U.S. Government Principles for Utilization and Care of Vertebrate Animals Used in Testing, Research, and Teaching, are actually extracted from some international principles that were established back in the early 80s. There are 9 of those principles. 4 of them directly apply to veterinary care. That's 4, 5, 6, and 7, and they basically say that studies will be done in such a manner as to avoid or minimize discomfort, pain, or distress. That when there is discomfort, pain, or distress, that it's relieved with appropriate sedation, analgesia, or anesthesia. Oops. And that when there's severe or chronic pain or distress, that the study shall be terminated as soon as scientifically possible. And then that the animal be provided appropriate living conditions. The 5th one there, number 8, also requires that the people who care for and use laboratory animals be appropriately trained. And since the veterinary staff is often involved in that process, I think this is a 5th one of the principles that's directly related to the veterinary care program. As far as ALAC goes, it's a peer-reviewed program with progressive standards. They too use the guide for the care and use of laboratory animals, which is going to be updated. It requires an institutional description. For a large institution like I used to manage, that's about 175 pages of description and about 200 pages of appendices. They come around every 3 years, and they take that description and make sure the description of your institution is actually the program that's on the ground at your institution, which is an interesting process. They either find you to have deficiencies or make suggestions in their report, and you are required to give annual reports in which you have to address both any deficiencies or suggestions. The thing that's different about ALAC is they're constantly incorporating the recent literature into their accreditation standards. So it's a constantly evolving, progressive peer review process. The guide states that the goal of the guide is to promote, and I've underlined the important parts of this, is to enhance animal well-being, the quality of biomedical research, and the advancement of biological knowledge. So what the guide recognizes is that high-quality animal care is an essential underpinning of sound science. Chapter 1, Institutional Policies and Responsibilities, requires that adequate veterinary care be provided, and the key term there is that including access to all animals for evaluation of health and well-being. So the veterinarian can go anywhere, anytime. And Chapter 3, under veterinary medical care, just lays out the essential components of a program of veterinary care, which is almost identical to what's in the Act with 2 exceptions, which I have underlined. For those in zoonotic control, including zoonotic control, zoonotic diseases are those diseases which are transferred from animal to man. And one of the things that both the Public Health Service, because of the guide, and ALAC requires a very extensive employee health program. And sometimes veterinarians get involved in things they really never wanted to get involved when it comes to that. As well as the assessment of animal well-being, which in my mind is the part dealing with the psychological well-being and environmental enhancement programs that have to be in place. So the bottom line is that the regulations and guidelines require the institution to provide the veterinarian with the adequate resources and the authority to do the job. The resources should be adequate to assure compliance with the regulations governing the provision of adequate veterinary care. These resources should also be adequate to manage the animal care program in a manner that minimizes non-experimental variability, which is a very important function of the program of veterinary care. The regulatory process often makes doing that job somewhat challenging. Changed it from difficult, but no. Regulations are static while our knowledge base is constantly growing. It's really not a peer-reviewed process. The veterinary medical officers that inspect us are well-trained, nice people, but they don't have the experience in a research environment that most laboratory animal veterinarians do, and this at times leads to interesting conversations. Changing the regulations is a complicated process, which I think puts the veterinary medical officers from the USDA in a very difficult position because they see different levels of compliance at different institutions. Emphasis is on specific items of noncompliance versus program quality, but that's the nature of the regulatory game. The inspection process often relies more on the review of records than evaluating the process, because they just come in once a year and they're just seeing a very narrow snapshot of what the program's actually like. But the environment we live in is one that's constantly evolving. I mean, there's more and more research. I mean, probably the biggest problem that veterinarians in a research environment face is there's the lack of funding to do the type of research that can actually directly improve animal welfare. While we hear a lot about performance-based standards, it's my experience that outcomes are often evaluated based upon the process in place, which I don't think is what performance-based standards are all about. And so we end up being more concerned about engineering standards sometimes than we should be. Programs appear to be evaluated as a collection of parts, which must all stand alone, not as a sum of their parts. And I think that's a very important concept, is the quality of your program, is that how you respond when the wheels start coming off. In life, we tend to live now in a zero defects environment, and this is certainly, I think, true for the regulatory funding and accrediting agency. Sometimes it calls into question the cost-benefit ratio of accepting only perfection, and I have a little example of that. I'm going to put that up first and let you think about that. Would you be satisfied if you did something right 99.99998% of the time? I'd feel pretty good about it. It's better than my track record most times. But you can have a program for enrichment of non-human primates. So you have 300 primates, and your records can indicate, and one of your requirements is you change treats every day, and your records can show that on one day, one technician forgot to give a new treat to one monkey, and you'll be written up as in being in non-compliance, even though you were in compliance 99.99.28% of the time. And that's just the nature of the process. But the other thing that we're beginning to see is the impact of the Office of Inspector General Audit Report, which took place which was published in September of 2005. In my mind, that was one of the worst pieces of report I don't know what it was supposed to be, but it was awful. They didn't normalize data. The criticisms they made of the IACUCs in there, they didn't seem to know the difference between what the policy required and what the regulations. And they actually, whoever did the audit, didn't seem to understand the difference between the act and the regulations because of what was in there. And so we're both the USDA and the regulated community, I think, is now having to deal with the fact that a very poor audit report was done. The other issue we're dealing now is harmonization of standards. That was mentioned a little bit. The European standards are interesting because the Council of Europe sets some standards, and they're not science-based. And then if the European Union accepts them, then they become the accomplishment of fatal law within Europe. The problem I have, and I've become very familiar with the European standards over the last couple of years, is sometimes these committees just seem to be raising the bar as an end and not as a means, and sometimes you just wonder how this is going to be effective. In fact, I was at a meeting in Europe, and they were talking about the new space requirements they were going to require for beagles. And I happened to know the speaker, and I waited till after it was over and went up to talk to her. And I said, I'm curious, because the first time I retired, I took our adult children to London for the week of Thanksgiving. I asked her why it cost me 125 pounds a night to keep my 2 adult children in a room I couldn't keep 2 beagles in. But anyway, under the law. Programmatic perfection is something we deal with at our institutions. You take a faculty committee who will go to their death arguing for academic freedom and put them on a regulatory committee, and they become the worst bureaucratic sticklers in the world. I see people acknowledging that. They're always looking for one size fits all. They want to take our world of gray and stick it into these little black and white cubby holes because it makes their life easier. And that's interesting to deal with from my perspective. So putting things in perspective, I think it's important to recognize that it's been 25 years since the new regs were passed instituting the IACUC. A generation has grown up within this system. Tremendous amount of progress has made in terms of the quality of care provided laboratory animals. And what we need to understand that an animal care and use program is a team effort where the veterinarians and the investigators, the IACUCs and everyone, and the regulatory agencies are working together to improve the quality of the care of animals. Future challenges is going to be pursuing perfection without compromising research and development. Striving for black and white answers in a world of gray. This is one thing I kind of enjoyed about retiring and getting away from the university was faculty committees. Whoa. Concentrating on fitting, in those, particularly the last 10 years, Concentrating on fitting everything into defined parameters can discourage innovation and reduce intellectual stimulation. Keeping the best and brightest involved in the process that demands uniformity is tough to do. Working together to promote animal welfare while facilitating research progress is what we should all be here for. So in summary, the laboratory animal veterinarian has to deal with a variety of regulations and requirements. We are given the resources and authority to manage progressive programs by those regulations and requirements. The regulatory process is event-oriented rather than program-oriented, which can create some frustrations. And I relate to you a story that one of my colleagues told me one time when they were during an ALAC site visit. He said, you know, being in this business of laboratory animal science is like paddling a boat upstream. You just can't quit paddling. And that's what I spent about 35 years of my life. And I think the most frustrating part of dealing with the regulations is that sometimes I'd get penalized for leaks that were correctly and effectively patched at the time they occurred. So I'll leave you with that, and thank you for inviting me.
Thank you, Dr. Bennett. Our next speaker is Dr. Barb Glenn. Dr. Glenn is the Managing Director of the Animal Biotechnology in the Food and Agriculture section of the Biotechnology Industry Organization. Previously, Dr. Barb worked as a research dairy scientist with the USDA's Agricultural Research Service, where she conducted research on energy and protein metabolism in lactating dairy cows. She later served as Executive Vice President and Scientific Liaison for the Federation of Animal Science Societies.
Thank you. Thank you very much, Christina. It's a pleasure to be here, and I'd like to thank the organizers for allowing myself in representing the animal biotech industry to make remarks. We had, I think, a ball putting together a program here, and I was pleased to be able to be a part of that. So I want to thank Professor Reppy for allowing us to work with you and you know, sort of achieve this balanced but very diverse interaction. So I look forward to more of that. Taylor shared a little bit about himself personally, so I get to do that too. I'm a mom and a 4-H leader. I have 3 4-H kids who've shown cattle for over a dozen years. We have the family dog, as someone referenced, that wags the tail. And so I think we all come here today with our own personal perspectives, and ours is certainly a very great appreciation and respect for healthy animals and their contribution to mankind. So that starts at the Glenn family home. So it's really my professional and personal pleasure to represent this industry where we have some of the most cutting-edge science being applied to some of the most compelling consumer benefits coming down the pipe. So with that, I'd like to tell you a little bit about how does this work, Christina? Do I have to point it over here? I didn't see Taylor doing that. He was like this.
Yeah, just any place. It's
How'd you do
working
that?
now. Push the forward arrow.
Okay, which one's the forward arrow?
Right, I think.
Green? This one?
You got it.
Is it going?
Yeah.
I don't,
Okay, how many lawyers and PhDs does it take to figure this out?
Taylor, I don't know, can you show her?
Okay.
Our excellent techie is coming down.
Yeah.
Okay, so it's this arrow.
Yeah.
This is it.
That's-
Okay, no, what I do? Come back. Help me out.
Go down to the little, get your arrow down to, oh, she's got to do it up there. Never mind.
Okay. Good interlude here. So my objective is to share with you the priorities of this industry. And you didn't teach me how to do this. Somebody going to do that? Okay, the priorities, and talk a little bit about the status of the industry with respect to genetic engineering of animals. Briefly make remarks with respect to our views on the domestic regulatory framework. Talk a little bit about international activity and how that's pushing us forward as well, and a little bit about the future. So which button do you want me to press?
Kathy, can you show her? I don't know the answer.
I put it behind me.
Okay, that worked. Okay, a little bit about bio. This is what I said about working together. We're really good at it. We've gotten a lot of practice over the last few months. Bio is the world's largest biotech trade organization. We have more than 1,100 members. About 700 of those are technology providers themselves, and then others are affiliate members of different types, universities, our state biotech associations, other providers of other services like counsel and products. But we do have the top 10 biotech and top 10 pharmaceutical companies as members. And I think what's most compelling about this advent of this science and technology is nearly 90% of our members are very small firms, and nearly 90% have no approved products. So it's an incredibly dynamic industry, very energetic, and a lot of moving parts. We do represent the big tent in bio, so 4 different sections: the biomedical, or the human health community and those applications, food and agriculture, and the industrial and environmental applications of biotechnology to products. I myself reside in the food and agriculture section, so I wanted to at least share that with you. So, okay, so promises have been talked about, I think, today already, but I just wanted to relate to you that in industry, we have members who are on this leading edge, and we have members who are participating in trying to provide all of these benefits moving forward. And again, doing this with genetic engineering, as is the topic of today's conference. And we're trying to improve animal health, develop more nutritious food, conserve the environment and animals themselves, and fourthly, but certainly not least, advancing human health using agricultural animals. Our priority, number 1, is public health and safety, and I think that goes without saying, but dovetailed directly with that, as I mentioned a few moments ago, is the humane care and use of animals, and we do this through compliance with the regulatory framework that Taylor has described, and we have a humane care and use principles statement with respect to what our industry believes. So of paramount importance to us is the care and well-being of the animals that we're using and working with. We also have as a priority then, of course, the safety and product approvals through a science-based regulatory process. We are interested in transparency to the maximum limit of the law so that the public then gains confidence in what we're doing and understands and actually benefits at the end from our products. The status of the use of genetically engineered agricultural animals is this. There is one approved product in the world from a genetically engineered animal at this time. There is one product which is a genetically engineered ornamental fish. It's actually a zebra fish that we heard about earlier today, is marketed in the United States. And additionally, I think a huge success story is that there are over 100 biotechnology-derived vaccines, biologics and diagnostics for use in animal health at this point in time. We've already heard about this, but I'll just go over it very quickly. It was actually in August of 2006 that the European Commission approved the first protein produced by a genetically engineered animal. This is a huge milestone. This is the first one. Remember I said 90% of our companies, we don't have approved products. We're starting here. A medical application, an approval of a product with the trade name Atrin, which is a human anti-clotting protein that's produced by transgenic goats in their milk. And so this is just a little picture of what's going on, but we're introducing the target protein construct into the embryo. This individual is born with the specific transgene and the ability to produce this protein, and they've developed a transgenic milk production herd. And after milking those animals through very specific processes, extracting that protein and having that purified drug. And this drug then is available for you and I, or those of us who have heart deficiencies where we require this. So this is a great step forward for this industry. With respect to the regulatory framework for these animals in the United States, these animals and their products will undergo a rigorous federal regulatory process coordinated among agencies, and it does include these aspects: regulation of food safety or safety to humans, safety of that therapeutic protein and its efficacy, with these first two being led and conducted by the FDA, animal welfare, we've heard about with respect to USDA's statutory authority, animal health being viewed by both FDA and USDA, as well as environmental impacts. So I think what we have here is a very, very strong regulatory framework for which this industry is glad to have, and we embrace, and we're moving forward, working with the agencies on this. Certainly we need a clear science-based regulatory path. It's essential. Without that, our research and development can wane. Investor confidence is impacted for this industry. public confidence decreases. So we support the advent of the strong regulatory process. In addition, international research and development is very active at this time, and risk assessment guidelines and regulatory frameworks are being developed. So with respect to BIO's policy on regulatory process for genetically engineered food animals, I thought I'd share some of those general aspects. BIO supports a coordinated U.S. government regulatory framework. I know we've heard earlier today about the 1986 regulatory coordinated framework that did include plants, microbes, as well as reference to animals. We support a science-based, rigorous process that is appropriate to the technologies and the products. I think Taylor was referencing this as a moving, evolving process in terms of science, R&D, and so we support appropriateness to these products. BIO supports the application by the Food and Drug Administration of the new animal drug provision as per the Federal Food, Drug, and Cosmetic Act. And I know we've already heard about this earlier today, but we do support this as a framework for regulation of these animals, where the transgene that affects structure and function of the animal is meeting the FDA's definition of a drug as per the Act. This process under FDA's drug approval requires finding of safety and efficacy. It's going to include safety to the animal that's actually, we could say, taking the drug. And for food and feed animals, it's the residue in the foods that have to be found safe for the consumer. So these products are going to be go through a very rigorous approval process. Therapeutic proteins, additionally, are regulated by the FDA as a drug and are biologic by the appropriate agency. And that's key to our progress as well. What are the advantages of this particular process? This is the way BIO views it, okay? This is our view. This is a mandatory approval process. This is, we could call this a gold standard for you and I. At the end of the day, this agency has reviewed this, and no stone has been left unturned in terms of review of the science. FDA has also publicly stated its position regulating the transgene as a new animal drug, and they're moving, we hope, forward with this. This would cover all transgenes, and I think that's an advantage to the use of animal biotechnology moving forward. It addresses safety of the transgene to the host animal, and of course, as I mentioned, includes food safety approval. In addition, BIO supports USDA's development of science-based and appropriate, I will say, non-duplicative regulatory oversight. We want to see a coordinated system that's, again, not leaving any stone unturned with respect to the development of these GE animals. And this is as per their statutory authority under the Animal Health Protection Act, as well as the Animal Welfare Act. And we certainly have been referencing the AWA quite a bit here just recently in the other speakers. BIO supports coordination again. I've emphasized this with respect to the two departments, FDA and USDA. We also support international coordination of food safety risk assessment and regulations of GE food animals and their products. That's something that we're very cognizant of. So in our view, of course, publication of this process is essential because it's the only way it's going to lead to approvals of products and commercialization. We think that this improves public transparency, and we are very confident that it will assist in consumer acceptance and credibility for the industry. I'd also like to just briefly summarize some of the international activity, because certainly there is a large volume of very high quality research and development that's going on across the globe. It's not just a domestic area of science, although we have leadership in this industry at this time. The Food and Agriculture Organization and the World Health Organization have published expert consultation proceedings with respect to food safety and genetic engineering of animals. They've done this in response to the Codex Alimentarius Commission, which is a food safety standard setting body, and just recently under the leadership of the U.S. delegation, a guideline was actually promulgated by the task force, and if all goes right, will be approved in the summer next year with respect to food safety risk assessment for rDNA animals. This is an incredible accomplishment for this industry, and this is on a global basis here, that we're putting forth this guideline, so that's an incredible accomplishment. The OECD also looks at aspects of food safety and other components of animal biotechnology. The World Animal Health Organization is under their purview of focus on animal health, has a working group on animal biotechnology, also looking at the genetic engineering. And in addition, even in the Cartagena Protocol on biosafety, or the Biosafety Protocol, which is an environmental international, I guess, statement, they're looking and looking at emerging technologies as well. So the point of that we have here is that there's a large amount of attention to this technology on a global basis. This is going to help drive us here domestically to advance and improve our industry and improve our pathway leading to approved products. So in conclusion, genetic engineering of animals holds huge promise for compelling benefits for mankind, not only domestically, but as I said, globally. Bio and the industry supports a coordinated science-based regulatory process. This is as strong as it can be that leads to approval of products across the spectrum of animal biotechnology. We support the efforts by FDA and the USDA and their leadership as they're moving forward to provide guidance in this area. And we know that international activity simply must not overtake our domestic leadership in the area of genetic engineering of animals. So with that, I thank you very much for your attention. Thank you. Okay, point this.
Oh, okay.
We need to point this. We're going to do tag team.
Our next speaker is Professor William Reppy. William Reppy is a professor here at Duke University School of Law. He began his career several decades ago with a clerkship in the United States Supreme Court, and since coming to Duke Law, what did you say?
Thanks a lot.
Since coming to Duke Law School, has advocated on behalf of animals in the state of North Carolina. He's an active member of the Duke Law faculty and has published a number of articles on animal law. I'd like to again acknowledge Professor Reppy's significant contribution to making this conference happen.
Thank you very much, Christina. Yes, I have been at Duke since 1970. I have been teaching animal law since 2001, and since we're giving a little personal disclosures, I have 4 dogs. One's a Dalmatian, and I'm sort of one of the voices of the pro-animal group at this conference. But my topic is the extent to which state anti-cruelty laws apply to research on animals in laboratories. All of the states, and I'm including the District of Columbia as one of them, and I'll just say, when I say 51 states, you know what I mean. It's just easier to include D.C. All of these jurisdictions have enacted anti-cruelty statutes. There's been a trend recently to include felony provisions with somewhat severe punishments, prison time. And most of the states now have felony provisions as well. First of all, I'm going to talk about how the federal law, the AWA, invites the states to apply these statutes to animal research that might involve cruelty. I'll talk then about how the statutes apply where there's no research exemption, but 36 of the 51 jurisdictions have enacted a provision annexed to the statute defining the crime of animal cruelty that to some degree exempts research on animals. Then after we see how these statutes apply when there is no exemption, we'll talk about interpreting the exemptions, just what do they do. The next point I will cover is the real possibility that some of these exemptions are actually unconstitutional. because they're so irrational. They extend in almost all states to felony animal cruelty, including torture. And then finally, wrapping up, asking should there be changes, keeping in mind that this session of our conference is dealing with public policy issues as they apply to bioengineering. All right. Let's see if I can do this. The arrow. Which one?
Good luck.
Is this one?
That one.
Yeah.
Shouldn't be that hard.
I had to point it back towards that corner. I don't know why you didn't, but.
It's working off that antenna over there, so it's working
Yeah.
everywhere in the
So
room.
you just.
Okay. When we ask, are the states permitted by Congress to apply their anti-cruelty laws to animal research in laboratories that are governed by the federal AWA, the answer is yes. Now, quite clearly, it must be that a huge majority of experiments involving animals in scientific research are at facilities governed by the federal AWA. If there's federal grant money going to the facility, it's covered. If the animals that are experimented on are purchased in interstate commerce, it's covered. So a great bulk of the experiments are governed by federal law under the commerce power and the spending power. And yes, this is going to sound a little bit like a law school lecture, because that's what I am, law school professor, and the lawyers and law students haven't had the privilege of that yet today. So scientists, bear with me. Certainly, Congress had the power in enacting the AWA to make a provision in there preempting state law. And Congress has done that in other areas. Very clearly, they did not. The Congress did not do that with respect to the federal AWA. And the provision that we see there, A8 of the section of the board, says that the states may also promulgate standards in addition to those standards that Congress has promulgated, that the U.S. Department of Agriculture has promulgated, and I believe the proper reading is also in addition to guidelines that the Institutional Animal Care and Use Committee has adopted. Additional standards certainly, I think, can be expressed through anti-cruelty statutes. They often have a list of things that are not to be done, such as torment, maim, mutilate, torture. And I'm given the spirit of the non-preemption provision. It's the logical interpretation is that what we're looking at here on the screen invites the states to apply their anti-cruelty statutes to what happens to animals in experiments in the laboratory. This would be confirmed by the provision I now have on the screen, asking the Secretary of Agriculture to work in cooperation with the states in implementing the goals of the federal AWA. There's no express preemption whatsoever. One federal court dealt with the issue as whether there's some implied preemption. This didn't deal with animal research. The case dealt with a dealer in exotic cats and other exotic animals subject to the AWA who was effectively zoned out of town. And it was argued that that is, in effect, stripping me of my federal AWA license. And the licensing provisions of the federal AWA impliedly tell this town that it cannot do that. No, no, no. The Seventh Circuit said it certainly can. So the invitation has been extended. But as I indicated, 36 of the 51 jurisdictions have some exemption for animal research, and a large number of them actually refer specifically to the federal AWA and said, this is what we are not regulating. We'll look at some of those statutes shortly. There are only 2 reported cases involving application of the state anti-cruelty laws to use of animals in research. And the first one I want to talk about was completely wrongly decided, and we shall see is no longer good law. But a researcher named Taub had been charged with several counts of animal cruelty, went to trial, the state law, went to trial. Not surprisingly, there was no conviction on most of them because, as we shall see, the state anti-cruelty laws are interpreted as permitting justified research. There was one conviction for failure to provide veterinary care to an animal, a monkey, that was injured. I don't remember exactly the nature of the injury, but needed veterinary care and was not provided. The High Court, the highest court of Maryland, reversed, doesn't even discuss in its opinion those provisions of the federal AWA that I just had on the screen, inviting the states to apply their anti-cruelty laws to research in laboratories governed by the AWA, but instead said, since the research lab and the particular research there, which was on a monkey and not on a mouse, well, at that time, remember, mice were not being regulated, was governed by the AWA. We do not believe the legislature intended this statute to apply. Well, that's just not a proper judicial function for an appellate court to engraft an exemption onto a criminal statute. I don't think any other state would ever do that because it seems so wrong. It's up to the legislature to state what the exemptions are to be. In any event, this is no longer good law. In the year 2001, the Maryland legislatures added a specific exemption referring to the federal AWA. What's interesting to note about it is certainly it's likely to get a different result than occurred in the Taub case. It's probable, I've never researched it, the federal regulations, and I have no access to the institutional IACUC guidelines that might be in effect in a Maryland laboratory, but probably failure to give veterinary care to this particular monkey would not be consistent with the applicable guidelines. So what the legislature did, I don't know whether he knew that it was doing this, was to say we don't like the result in the Taub case. We want something much narrower. We'll look at this again shortly, and we'll find out that it's probably almost worthless to researchers. Several of the exemptions turn out to be almost of no benefit to researchers. And we learned that from the second case that's reported involving a prosecution by a state prosecutor for pain and suffering by an animal in a scientific experiment. And that case comes out of New Jersey, and it was the school board running a high school that was prosecuted. The school board knew that the high school was authorizing a 17-year-old student to deal with chickens and introduce through viruses cancer into the chickens that caused lesions and pain and killed some of them. And there was a prosecution brought, and it was thrown out. It's interesting to look at the statute that was invoked by the New Jersey prosecutor. Was the cruelty unnecessary? Most statutes probably say unjustifiable, but this one says unnecessary. Florida says needless. But this was a word that's going to cause some problems if taken literally, because this 17-year-old could have learned about cancer viruses by reading about it, by maybe using some computer models, and it probably wasn't at all necessary for this high school student to be dealing with the chickens in a way that caused pain. But the court, first holding that the exemption did not apply because the high school had never gone to the State Department of Health to get an authorization. So the exemption dropped out of the case, and that's why I'm saying that this shows you what happens when there's no exemption at all. The court said that cruelty, even though it was worded, these words are not in there, required some sort of evilness, and if there was a real and valid purpose, there could be pain. This certainly read unnecessary out of it. Valid purpose is very, very different than necessary. So basically, what the court did was rewrite the statute to provide that if there was justification for the scientific experiment, it was not a criminal act under the statute. As I said, many of the state statutes actually use the word justifiable or unjustifiable in it. We would expect every court to agree with this decision. And so it seems then that we don't need the researchers, the laboratories, the universities don't need an exemption. Why should they want to preclude the state from policing unjustifiable conduct with animals? Well, in any event, despite this lack of need, 36 jurisdictions have enacted exemptions, so we'll now begin to look at them. Let's remember the Maryland exemption, research conducted in accordance with the AWA, sorry for the typo there, the AWASA, I have a couple of typos, I apologize for them. I was very busy organizing this conference and did not proofread my slides. Apologize. Well, I mean, research conducted in accordance with, how often will the state criminal statute be violated when justifiability is the standard in a situation where everything that the AWA through the Ag Department regulations and the Institutional Care Committee guidelines is being obeyed, not very often. This is one of those exemptions that I think is worthless, and in a moment we will see that maybe it is actually harmful to research laboratories and they would be best advised to get it repealed. Some of the state exemptions refer to properly conducted scientific experiments. Same point. What's the benefit of that? Isn't that the same thing as it's justifiable? Bona fide, same point. I don't see any benefit being got out of these. But what's the possible detriment? An exemption that's freestanding, it's not listed amongst the elements of the crime, is construed by courts as creating an affirmative defense. And as a matter of criminal procedure law, if bona fide experiment or properly conducted experiment is the same issue as justifiable experiment, that moves the element of the prosecution from having to prove in its case in chief lack of bona fides or lack of justification and makes it an affirmative defense, and the researcher then has, in the defense case, got to go forward with a prima facie case of bona fides or properly conducted. This is possible, that's all I'm saying. Another possibility that the exemption actually is harmful to the research laboratory and the researchers rather than beneficial is the possibility that it will be seen as defining justification. If we go back to the Maryland statute, it said experiments conducted in accordance with the AWA. Isn't that susceptible of the interpretation that the legislature says if you're not conducting it in accordance with the AWA, you're not justified? That's a possibility. I don't know if it's going to happen. But Hawaii is similar. I think the reference to accepted medical and educational practices would include the guidelines made under the federal AWA. So the Hawaii statute has the same potential that you can't justify what you did once you're outside of accepted standards. So if I were a researcher in Hawaii, I'd like to see that repealed. And if I were a researcher in Maryland, I would like to see here's another one of them. If you're knowingly operating outside the provisions of the Institutional Care Committee in New Mexico, does that mean you're unjustified and that the prosecution has to prove no more? If I were a New Mexico researcher, I'd want to get rid of that one too. Because I don't think it's beneficial to the researchers, and I can see the potential here that it's harmful. Now I'm talking about interpretation. There's some interesting interpretation issues. Research governed by, that is broad enough if we think that accepted educational and medical practices includes the AWA, that even though you were in violation in Hawaii, you were still governed by this, and the federal enforcers didn't do anything. You see how this is more beneficial to the researcher than the Maryland version, which was consistent with, governed by, includes gross violations of the federal standards, but with no enforcement. And when we get shortly to constitutional issues, we'll see that any time there's a nice hole there with no enforcement, we have some possible problems to deal with. And that's what I'm going to get to now, the constitutional problem. The issue is equal protection of the law. The 14th Amendment says to the states that you may not pass a statute that denies equal protection to a law. A statute that says to a researcher, you may torture any animal you want to in your laboratory, but also says to the horse groomer, you may not torture an animal, and says to the operator of a pet motel, you may not torture an animal, you have no exemption, raises the issue starkly. All three of those people interact daily in their professional lives with animals. But to signal out researchers and say you may torture is, to me, totally irrational. And the test is any rational basis. And if anybody of you wants to talk to me during our break and tell me what the rational basis is for permitting torture. Now, I see some rational basis for maiming in a justified experiment sometimes. I can see a rational basis for tormenting in a psychology experiment maybe. But I don't see any rational basis for torture. And as I said, the exemptions extend to the most atrocious wrongs described in felony anti-cruelty statutes. So I think my own home state's exemption is unconstitutional, and I've written an article about that. Lawful doesn't change anything. It's clear that lawful does not mean not violation of the felony cruelty statute, because originally it was enacted specially tied to the felony cruelty statute. Lawful must mean like you didn't have illegal aliens working on the animals or something like that. No, it can't deal with cruelty because there's an exemption to cruelty. I'm running out of time here. Look at this one. Too broad. Facilities, licensed under the provisions of the Federal Animal Act. This was going to be unconstitutional. You look at that, oh, it's just ceding the control to the federal government. What's wrong with that? But remember, facilities under the provisions of the Animal Welfare Act conduct gobs of experiments on mice. If they have a few dogs, then they're subject to the AWA. So there's a giant hole here. And as I read this, if a cat wandered into the experiment and jumped on the researcher and enraged the researcher who grabbed the cat and started to torture it, this was done at a facility governed by the AWA, and it's just totally irrational to have it that broad. It's just a mistake in the drafting. I will close. I'm getting the sign here that I'm out of time, but remember my other colleagues here gave me extra time by only taking 20 minutes. I will close. Yeah, I will close by conceding that I think it's constitutional for a state to reject the invitation in the AWA that we saw in the first two slides to extend its anti-cruelty law to the research, not facility, but research governed by the AWA, and even governed by, so that if there's a serious wrong and the federal government is not doing anything about it, the state statute saying we have no jurisdiction, I think is rational. It's sort of a money-saving idea. Why should two sovereigns, the state, overlook these laboratories? One's enough. Well, what's the argument to the contrary, that it's irrational? Well, one possibility of lack of rationality is that the feds don't look very closely all the time at what's going on. The inspections are not very frequent. I asked Betty Golden Tires, we were walking over, if she thought that the institutional animal care committee at each facility had somebody on call if a person in the laboratory saw horrible cruelty going on. I said, no. They'd follow up a report, but they wouldn't be immediately there, like you call the cop. Somebody's torturing a monkey, please get over here. So federal enforcement is sporadic. My final slide, I promise you. The other problem is fairly light penalty for even most horrible felony type of animal cruelty, $2,500. Now, yes, you could lose your federal funding, maybe. Maybe there could be a loss of license, but probably that's all it is, a civil fine. Whereas I just chose one state to show you what the penalty in the criminal side of the state prosecution for felony cruelty could be. Go to prison. So, in conclusion, what should be done? Every state should redesign its law if it's necessary to at least provide that torture can be prosecuted, torture in the lab can be prosecuted by the state because the federal oversight is such that they might miss it. Beyond that, I don't have many recommendations. If you were a researcher, you probably are surprised that you might be worse off in some states because they have exemptions. I don't care if you're you get rid of them. They shouldn't do that. They're silly exemptions. And clean up the law here. And thank you very much.
Do we have questions?
Are you on AVMA's Animal Welfare Committee?
Questions? Collecting the questions?
Oh, we have some help.
Monica Schroeder represents the lab animal. She's really good.
Actually, I had a question about the study that's going on elephants and
You're
training.
the most popular one.
Oh, goody.
Yeah.
And I didn't even write one for you.
Make sure you read them.
That's
They're
right.
not nasty.
That's what I'm doing. The first question is, could you explain more how the once-a-year inspection is limited with regard to the investigator's ability to understand lack of compliance with humane standards? Could you explain more how the once-a-year inspection is limited with regard to the investigator's ability to understand lack of compliance with humane standards? I'm not sure what the question is. The investigator's understanding of compliance with the standards that are in place at the institution has to do with the IACUC's, the Institutional Animal Care and Use Committee's role and the whole protocol review and education process. Whether you were inspected once a year, twice a year, 3 times a year, or 4 times a year wouldn't make any difference. One of the requirements is that the people working with animals understand the regulations. And so this is a educational requirement that's in place 365 days a year. So how often you're inspected really doesn't make any difference in terms of what they do or do not understand. What animals fall between the gaps of, this should be the Animal Welfare Act, ALAC. It's Animal Welfare, your organization's acronym. Like smaller private colleges, and how can these gaps be filled? Well, between ALAC, Public Health Service and ALAC cover all vertebrate animals, whether they be warm or cold-blooded. So majority of animals would be covered if you fell under either one of those. In fact, I think there's some consideration in the, it's not going to be called a rewrite, but the update of the guide to consider invertebrate animals, because there are some invertebrate animals which are certainly sentient that are used in research, some of the mollusks, octopus and things like this. The things that would probably fall through the cracks would be amphibians, fish, reptiles, and mice and rats that are used in small colleges. But, I mean, that would be my guess. I don't know, because I don't know what's going on in small colleges. Do you think there is a viable way for accreditation and evaluation to become program-oriented? Well, accreditation is program-oriented. I mean, you fill out the University of Illinois at Chicago, where I was, our program description was over 300 pages long. And so, and that's what they did. They evaluated the program. The problem with the federal regulatory process, it's a checklist inspection sheet, like when you take your car in and, you know, check the fluid. And so there's not really a way to do a program evaluation. It's been my impression the federal government is not set up to really look at performance standards or program evaluations. They look at item by item whether you comply with the regs, and that's the way it's set. It would take a change in mindset, I think, of how regulations in general are applied by government agencies. Do you believe existing laws adequately protect the welfare of lab animals? Would you change anything in the law? Well, one of the silliest things that's in the regulation, and one of the good things that being able to comment on the policy says, is one of the requirements is when you ship animals, the veterinarian has to have provided an examination and health certificate within 10 days of shipping the animal in order to protect other animals from diseases that are spread or humans. Well, if we had diseases which had 10-day incubation periods, we wouldn't have any problem in the world, because, you know, if somebody had a cold, you could get far enough away from them. So that's kind of a silly part of the regulations, but to change it would be very difficult. As far as the adequate protection, the welfare of lab animals, I think one thing that we mentioned was the IRAC principles. And the IRAC principles do apply to NIH-funded and ALAC-accredited facilities who use mice, rats, birds, anything like this. And that first one says, in compliance with applicable federal laws. And so I actually believe that since my guess is probably well over 98% of the animals that are used, and I'm just guessing, but certainly over 95 are covered by either Public Health Service or ALAC, which would mean a lot of the non-covered AWA species do have appropriate welfare. The guide, when you read it, is a very interesting document. It's considered the gold standard for providing care. Other goodies, or am I off the hook?
The question to me is, if a laboratory purchases rats by going across the state line to get them, is it subject to the AWA? No, because of the nature of the animal. And I'm sorry I was confused about that. If they bought a monkey across the state line, it is my understanding that makes this experiment on the monkey governed by the law. Anybody from USDA think I'm wrong on that?
Depends on the reason for breeding the rats. Purpose-bred rats are excluded, but not all rats.
Oh, yeah. Right. That's right. If the mouse is not bred for the purpose of experimentation, it lies outside the exclusion of the AWA. I always wondered how the enforcers know the breeding history. I really did. But no, I mean, if you know the mouse was bred for research and you can buy it across the state line and continue to use it without being subject to AWA.
Okay. The question is it realistic to expect the lay community representatives to do anything other than approve recommendations of the veterinarian? Any examples of lay members changing a practice? And the 1985 amendment to the Animal Welfare Act that established the institutional animal care and use committees require that there be this lay person. And what's really important, and I would encourage people to submit comment on this regarding the policy, is that the lay person is intended to represent community concerns for the welfare of the animal subjects. And USDA's own policy has dropped the latter part of it, just saying that they are a community representative, rather than adding the key part to represent community concerns for the welfare of animal subjects. And certainly there are a number of cases of individuals that I've spoken with that have served as lay members, particularly those that serve for an extended period of time, and did feel that they developed a rapport and were respected for issues that they raised. I think it certainly takes a certain kind of person with a substantial backbone to raise issues, but it does happen. By the same token, we encourage, and there's nothing preventing any institution from putting 2 lay members on their institutional animal care and use committee, and that would help fortify if one of them wanted to speak up, or you don't also have to feel that it's critical that you attend every meeting, that you can have the other lay member at least there to make sure there's some representation.
Joyce, you want to?
Sure. This asks, do you really believe that if animals were not patentable subject matter, there would be less suffering? And as I understand it, patenting is the engine that drives innovation, invention. It's the ability to protect one's time and money put into the invention. That is the goal of getting the product patented. If patenting were not available, I don't think we would be seeing as much innovation as we are seeing. So would less animals suffer? Yes. The reverse of that is what other speakers have talked about. You know, would that be the best thing for human society? And I'll let them answer that. But I think fewer animals would be used if patenting were not driving the biotech industry.
Barb, I think Barb, did you?
Want me to go? Okay. Thank you. Okay, this is a really good question, folks. Here it is.
What do you think are the consequences if the technology cannot be understood by the general public? So I would add, let's just narrow that down and say in the United States, and see how I could possibly answer that. So we're talking about genetic engineering of animals. We've talked a lot about the compelling benefits that are coming. So let's see if I can make a couple points. The International Food Information Council does an annual consumer opinion survey, and this is about, so let's relegate this to food applications of biotechnology. And it turns out with respect to their understanding of food and food safety and so forth, biotechnology is not top of mind in the United States to consumers, and it never has been in over 10 years of their consumer research that they've done. In fact, however, we have over 60 approved plant food products, don't we, that are genetically engineered. About 70% of foods in grocery stores have these products, these foods in them, and never has there been one human health incident, case, symptom as a result of that. So that doesn't answer the question, does it? But it tells us that with strong federal oversight and regulatory approval, we have that area of agricultural biotechnology has been highly successful in the United States, and indeed globally, and it is growing globally. So what do we know about animal biotechnology? Same question. There has been a nominal amount, a good library is being built on consumer opinion research with respect to animal biotechnology, and we've learned a couple things about how people feel about it. Number one, they're totally unaware of it. You can ask the question, have you heard of cloning? And most folks have heard of Dolly. Not most, about 40%. But if you ask them if they've heard of animal biotechnology or genetic engineering, the answer is no for about 80 to 85% of us. So we have a situation where you and I don't even understand this technology. So that offers some opportunity. One would be that we've also learned that their opinions are very soft, so if you provide them additional information, they actually shift. If you provide them fact-based information, they shift their opinions in terms of favorability. Not only do they need facts, so they need government regulatory assurance that in this case, the food would be safe from animals of this type. So I didn't answer the question, did I? But I tried to provide you some information that industry is viewing and that we're reviewing with respect to consumer acceptance. And we feel like this is the gee whiz phase of genetic engineering. The tuna pig, the omega-3 fatty acid pork you heard about earlier today, heart-healthy bacon. All I heard for a week after that was on radio talk shows was how I was going to eat a pound of bacon a day. This is the gee whiz time for the technology, so maybe it's our responsibility to provide facts and help folks understand the benefits coming for them. So long answer. Thank you.
Bill, did you have another one?
I got this card, which is not a question, but a correction of a mistake I had made, that the penalty under the AWA for torturing an animal that is a violation of the regulations or guidelines is $3,750, not $2,500, which I had on my final slide. Remember, my conclusion was that it's not unconstitutional because of this discrepancy in penalties for a state to decide it's not going to regulate at all. And thanks to whoever brought this up, that just strengthens that conclusion. That was my conclusion, that it's not unconstitutional. Thank you.
Okay, I think we have a 10-minute break. We start back at 3:40.
Nice job.
Thanks.
You got all the questions.